Welcome to The Critical Path, Greater Vancouver Realtors' professionalism and innovation-focused podcast. I'm your host, Jesse Lalime. Each episode, we sit down with industry leaders to discuss the critical issues affecting our profession and the paths we must take to overcome them. Now, imagine this. You've just been sued by a former client. They're claiming you misrepresented the square footage on the condo you helped them buy almost a year ago. You're certain you didn't do anything wrong. In fact, you hired a professional company to do the measurements. And now you're starting to get worried about what a lawsuit will do to your reputation and your business. Would you know what to do next? Would you know to contact the Real Estate Errors and Omissions Insurance Corporation of BC, or more simply, E&O? E&O is the organization that offers insurance, protection, guidance, and more to BC's realtors when they face litigation from clients. From claims of misrepresentation to fraud and everything in between, E&O has seen it all. And today we welcome E&O's EO, Leslie Howatt, to dig deeper into what E&O is, what they do, offer some sound advice, and maybe share a horror story or two. Leslie, welcome to The Critical Path.
Thank you very much. I'm really happy to be here and excited to share the war stories and maybe scare a few people.
I think this is going to be a really interesting episode for people because it's a little bit like kind of, reading the magazines at the front of the supermarket when you're going through the tabloids? Yeah, right. And just getting some of the greasy stories about some of the things that can happen out there, right? So, let's just get started with, as I mentioned in the top, for our members who maybe don't know a lot about E&O and what they are, tell us who the Real Estate Errors and Omissions Insurance Corporation of BC is and what you do.
So, as you said, we're the professional liability insurer for all real estate licensees in BC. So that encompasses trading licensees, strata managers, property managers, anybody or organization with a license. We were created 38 years ago, actually, under what was then the Real Estate Act, and we've continued on. We're now in our 38th policy year.
Wow.
So we've been around for quite a while. So we provide insurance coverage under a policy that we call the indemnity plan. And that plan protects real estate agents against liability for errors and omissions in the provision of their professional duties, providing real estate services under the Act. Essentially, when somebody claims that their realtor has made a mistake and they're seeking damages from them, that realtor would report the claim to us. Probably one of the first things to do is report it to first your managing broker and then to us. Assuming it's a covered claim, we'd open a file, assign a lawyer to defend the matter, to assess the matter, and basically help the realtor and brokerage to deal with the situation.
And you mentioned, provisions of coverage. Most members should know that as realtors, they are covered under some kind of insurance from E&O, but there are some nuances there, right? What exactly does this insurance cover? And maybe more importantly, what does it not cover?
Well, in terms of coverage, kind of big picture, and how much coverage is there, the policy currently provides up to $2 million per claim. We actually doubled the coverage from $1 million in 2024 without increasing the fees, I'm happy to say. So that's a really great layer of primary coverage for all realtors. We also have some what we call sublimits, so a smaller amount of coverage, $250,000 for property damage type claims. And we recently put in a $500,000 sublimit for what we call social engineering fraud claims. Social engineering fraud claims are defined in our policy as the intentional misleading of a person into sending or paying money based on false information that's provided to that person. So that kind of claim has hit, we've had a few of them unfortunately, but it hits brokerages who are transferring funds electronically and don't, unfortunately, have proper systems and policies in place to protect them, one of which would be secondary verification. So in other words, having the person contact directly, usually by phone or whatever, the person who's supposedly giving the payment instructions to make sure that it's all legitimate. What happens is hackers get into systems and pretend to be somebody they're not, and busy people don't always check things, and the next thing they know, they've transferred the money into a bank account, often who knows where, the money will never be seen again, and the client wants the money. Where is it? And that would result in a claim. That's probably a good opportunity for me to plug our new CyberGuard loss prevention tools that we introduced a few months ago. So this is available on our website for every licensee in BC for free. Like, I've got to emphasize the free part. It's not insurance, it's loss prevention tools. And it's for individual licensees, and it's for brokerages as well. And what it does, it helps you to stay cyber safe. And in this day and age, I think we're all afraid of being hacked or, emailing the wrong person or clicking the wrong link or what have you. It can happen to anybody. And so these loss prevention tools will help you to stay safe. If you're a brokerage, it will provide training videos for your staff. It'll send out, phishing campaigns to see if people do click on the wrong thing, training type things. And for individuals as well, it will give you tips on how to make sure that you don't become the victim of a cybercrime. So licensees can log into our website. If you need the password, just call our office. We'll help you out, and it's free. There's also a 24/7 helpline, which any licensee can call anytime for help with cyber issues.
The program's pretty amazing. I mean, we actually had, and you helped set us up with Andrew Martin from DynaRisk, who was a guest on the podcast just a couple episodes ago. There's some, for like you mentioned, for a free product, there's some really extensive and valuable coverage there, right? I mean, you talked about the training programs. Andrew talked to us about tailoring those programs, right? You can talk with them and they will tailor a program for you and your people. I mean, the value is off the charts.
It is. And I would encourage everybody to sign up for it. I mean, there's not many free things in life, but there you have it. It's there. It takes me 10 minutes maybe to sign up for it. It's not a big interference with your day.
Mm-hmm. And that's, one of the things we also heard from Andrew, and, you just mentioned it too, is, the speed at which business works sometimes makes people just kind of feel like this isn't maybe a priority or this isn't an important thing. And it really can, just for a few minutes, really provide you with some extensive coverage, right?
Yeah, it's never a priority until you need it, unfortunately. That's the way with insurance. People don't like insurance until they actually have a claim and they're thankful that they've got it. The cyber loss prevention tools as well, hopefully it'll help you avoid being the victim of a cyber type issue. So it's worth it.
Again, for that training, right? I mean, that can help pick problems out before they start. That's very important.
Yeah, and vulnerability scanning as well to see if your email is showing up on the dark web and that kind of thing.
Yeah. Dark web monitoring. Very, very cool stuff.
Yeah, it's good.
And so what about some of the things that aren't covered?
Well, like every insurance policy, not every single thing or claim is covered. Some of the more typical types of things that a licensee might want to know is not covered would be acts of fraud, for example. That's an intent to deceive.
Intentional act of fraud.
Insurance doesn't generally cover that sort of thing. Bodily injury claims don't fall under our policy. Claims are disputes over commissions and fees. If brokerages are fighting over who should get what, that's not something that involves us. If your client is suing you saying you didn't deserve those fees or I'm not paying you or that sort of thing, that does not fall within coverage. Discrimination, defamation, not covered. Those would be things typically covered under a CGL or comprehensive general liability policy that the brokerage would likely have. When you're buying or selling your own home or your spouse's home, that's not covered either. That's probably our number one coverage question. Am I covered if I list my own property for sale? The answer is no, you're not. Always better to have somebody else list your property for sale, and ideally not a team member because, you're part of that team. So
try to get a level of separation.
Exactly.
Yeah. Mm-hmm.
Those are really the key things, I'd say. I mean, the policy sets out what's covered and not covered.
Back to the kind of the more, traditional kind of claims that you deal with, because, as we mentioned, that's kind of a little bit of a, maybe not so new, but it's, cybersecurity is maybe a little bit out there for some people. But, the more common kinds of claims you receive, and, we've mentioned things off the top like misrepresentation for, measurements or things like that. What are some of the more common claims E&O does receive? And then to follow up, what should our members be doing to avoid some of these common pitfalls?
Yeah. Well, about 50% of our claims are for misrepresentation, and I would also lump non-disclosure into that.
Okay.
About 25% or so are negligence claims relating to contracts, probably drafting of a contract, that sort of thing. And the rest is a mixed bag of things like breach of fiduciary duty, strata and property management claims, and just general negligence. But the thing about claims is that it is a complete mixed bag. There's so many different things that could be misrepresented, for example, or not disclosed. And so, it's hard to sort of lump things into big categories, but the types of claims that would be common, of course, the misrepresentation about the square footage is one that we see. It drives people crazy. I've noticed when somebody feels like they've gotten a property that's smaller than was represented, they get very emotional.
It's personal almost, right?
It kind of is. Yeah, definitely. Boundary issues. Realtors represent the yard is within the fence, but unbeknownst to them, perhaps the fence is partly on the neighbor's yard or on a green belt owned by the city, so it's not exactly as it's presented. We see licensees representing properties as having legal suites or authorized suites when they're not. Mm-hmm. That's fairly common. Failing to advise a buyer that an addition or renovations are done without permits would be something we see a lot of. Poor drafting, of course, of contracts, maybe not being clear about what's included or excluded in the contract. That hot tub, for example, is it a fixture? Always best to be clear when you're drafting contracts. Tax issues, misrepresentations about GST. Another thing that we see fairly often, and negligence in valuing properties. That's another one that people get very emotional about. Again, they feel like a seller who feels they've undersold their property. It can get very heated for sure. And then there's some also crazy claims. I call them crazy, but some of the topics that we deal with would surprise you. We just won a trial recently where one of the allegations against the buyer's agent was for representing that the property was in a town that was deer friendly. And a few years after the purchase, I guess there was a deer cull. And she felt, amongst other things, that the realtor had misrepresented it. We did win the trial, I'm happy to say. So all kinds of things.
That is out there. I mean, deer friendly. Where's the definition on that to start with, right? And then we're going to have a cull, and wow. That's pretty wild.
Yeah, interesting.
This is kind of what you're dealing with on a day-to-day basis, right?
Yeah, absolutely. It never ceases to amaze me, some of the things. We had another one, I don't think it went to trial, but the allegation was for failing to advise the buyer that her property was near a gun club. And, she moved in and then started to hear noise from a gun club and felt that her licensee should have warned her about that. You asked me about how to avoid the claims.
Because it sounds like a lot of this is, due diligence, right? Some of it can just be a lack of or poor communication, right? And things that maybe are not quite so hard to deal with when you look back.
Yeah, I mean, there's a whole mixed bag of reasons as to why claims happen. I think, in my opinion, one of the biggest reasons is people that are acting outside of their area of expertise. a city realtor selling a farm, or a residential realtor selling a business. Somebody who's never sold a property on First Nations land, dealing with that. These are complicated transactions. And if you don't know what you're doing, you're more likely to slip up. So there was an old saying from, I think it was lotteries, know your limits, stay within it. That would be my advice. Kind of stay in your lane.
Sure.
Know what you're good at, and that's probably the best thing you can do for your client as well. I look for experts in whatever area to help me. And, I think that's the best way to run your practice is stick to your area of expertise.
Real estate's a really kind of interconnected ecosystem, right? So the idea that, you should be able to refer to somebody or defer to somebody's knowledge who might be outside your own or greater than your own, right? But then it becomes that personal thing where, you're talking about when people are feeling like they've been aggrieved, a realtor maybe could take that the wrong way when somebody might say, well, I want an expert opinion on it. I'm your expert, right? So I could see where ego maybe gets in the way a little bit.
Absolutely, but nobody's an expert at everything.
Exactly.
You really have to know your limits. And I think the best thing you can do for your client is to acknowledge that and send them off to the right person. I mean, most realtors are not going to do the house inspection because they're not an expert in house inspections. No one expects that they would be. And that's why you refer people to a proper qualified inspector or engineer or what have you.
So let's kind of go back to the beginning where I was presenting that little kind of case scenario at the top of the podcast here. Say I'm a realtor and I've just gotten sued. No fault of my own, but a client claims I'm misrepresenting something. Or what should I do next?
Yeah, I think the first thing you should do is talk to a managing broker. Yeah. They're there to help you in these situations. Maybe they can help diffuse it right then and there. If not, they will help you to report it to our office. So that needs to be done in writing. But before that, you're always free to call our office. Our lawyers take phone calls every day from licensees looking for help, not sure if they've got a claim to report or not. Sometimes we can help them avoid it in the first place. So we're available to licensees, just a phone call away. But if you are reporting a claim, you would probably email in to us your key documents, a description of what happened, a copy of the claim. Claims may not all be in litigation. Sometimes they're just an angry email from your client demanding something from you. So we would gather together the information. We'd assign one of our staff lawyers to the matter, and they would assess the claim. And if it's defensible, of course, we'll raise every defense. Sometimes realtors make mistakes and there are damages. We would probably settle those cases. But interestingly, out of the claims that we have closed in the last 10 years, and I think this goes far beyond that even, only 15% of them result in indemnity payments to the claimant from E&O. So 85% of the claims are closed without actually making a payment to the claimant.
And I would imagine a lot of it is on a case-by-case basis, right? But like typically from the start of the process to the beginning, it can be, as short or as long as the process plays out, right, given the particulars.
Yeah, it is a case-by-case. Small claims cases are up to $35,000 currently. Those kind of get driven by the court registry themselves. They set things like a settlement conference and they set the trial dates. Most small claims matters should be finished within a year and a half tops. Supreme Court cases are more party-driven, if I can call it that. The plaintiff will usually set the trial date. The parties will set discoveries with each other. So how fast or slow it goes probably depends on the parties involved and how long of a trial. You have to wait longer to get a trial date that's longer. Mm-hmm. It's a very stressful situation for licensees, though. To be accused of doing something wrong in your professional capacity is very stressful for people. And, I have a lot of empathy for what they go through, and I see it. I've seen people break down on witness stands, and they haven't done anything wrong. It's just the stress of the matter just is really tough. So obviously, the best thing to do is to avoid being in that situation in the first place.
Mm-hmm. And it's good to have, the resource of somebody like E&O, because again, that stress can really weigh on you. And when you feel like you have an ally or somebody, not necessarily holding your hand per se, but, somebody who's really knowledgeable in what's happening and can kind of speak with a level of kind of clarity and confidence about it, it's a big help.
Yeah, our lawyers specialize in this area. For me, I've practiced law for about 35 years, I guess, and this has been my prime focus, my entire focus since I've been at E&O 30 years now, and even in private practice before that. So you really get to know the area of law really, really well. We aren't cheerleaders, though. I think that's something people have to remember. We're there to act in your best interests, but we're going to tell you what we think. Sometimes people don't like to hear that we think, we do have exposure on this case and we do feel that it needs to be resolved. But that's our job, and it's hard to hear sometimes, but again, that's what we do.
Well, and hard conversations need to be had sometimes. That's just kind of the reality and the nature of business, right? I'm kind of loath to press you for more because I feel like we've gotten some pretty entertaining stories already about deer-friendly neighborhoods and culling. But you've seen your share, right? In the time you've been at E&O. What are some of the more kind of out there stories that you've heard or seen?
Well, I've had a few trials that were surprising, I guess. Trials you'd think should never happen, but they do. I remember doing a trial in Victoria. The plaintiff was a retired lawyer from the U.S. Who felt that her realtor had misrepresented the house to her. And the representation was that it was cherry cabinetry in the kitchen in a 2-car garage. She felt that although it was a 2-car garage, it wasn't big enough to fit 2 proper-sized cars in it. So she felt that was a misrepresentation. And as for the kitchen, although the kitchen was cherry-stained wood, it wasn't cherry wood. It was maple wood, which, by the way, at the time was exactly the same value as cherry wood. We ended up going through a 2-day trial over these issues. They were dismissed at the end of the day. The realtor was exonerated, but had to go through 2 days of trial.
The whole rigmarole.
Exactly.
Yeah. Mm-hmm.
The first Supreme Court trial I ever did lasted a week, and the big issue there was misrepresentation about the size of the house. The house was 4,000 square feet, and it was off by about 150 square feet. This particular plaintiff felt that he'd suffered terrible damages and felt that he should be paid the cost of building a 150 square foot addition to his house. Well, again, that didn't happen. In that case, though, the realtor was found to have been negligent, hadn't taken the proper care in coming up with the square footage. But because this buyer had seen the property himself many times before entering into a contract, he relied on his own viewing of the house and had not, in fact, suffered any damages according to the evidence in front of the court. So another case dismissed. I did have one very, I'd call it bizarre case in an area that, unbeknownst to the realtor, was known to flood seasonally. Perhaps the fact that there was a rowboat on the deck of the house might have been the first clue. I mean, who would have guessed? But the people bought the house, and then shortly thereafter, during the seasonal rains, discovered that it rained so much that you couldn't get from the deck to the street without getting in the rowboat and rowing to the street.
It wasn't just decor, it's functional.
Who would have known? But that trial, the plaintiff brought in all the now adult neighbors who talked about how when they were kids growing up and every time it rained really hard, they'd all walk over to the top of the hill to see if this house was underwater or not. And anyways, the evidence came out that it was a well-known problem in the area that this house almost flooded every year. We actually lost that one.
Really?
But lost it, but with almost no damages. So it was, it was different, let's say.
I can imagine the book you could write about some of this stuff. We're just about at the end of our time here. Is there any kind of last message you want to leave with our listeners, or any kind of advice, anything that comes to mind?
Well, use our services. I think we really want to help licensees to avoid having claims made against them. So we do as much loss prevention as we can. Our lawyers, myself included, will go out to brokerages and do what we call brokerage talks. We'll talk about whatever issues you want us to talk about. We'll give you advice on how to not get sued. And what to do if it does happen. We're here to support, and there's resources on our website as well, all kinds of loss prevention information. We publish a risk report. It's emailed to every licensee every quarter. There's good stuff in there. Mm-hmm. Don't just delete it.
Well, and I know we've worked with E&O in the past to have events here for our members to kind of talk a little bit more about these issues and that kind of stuff. So I mean, it's really, like, if you're listening, these are free, powerful things that you can take advantage of today, right? So that's really the key message I think we want people to take away from today's conversation, right?
And if you think you've got a claim or potential claim, just pick up the phone and call us. It's not to be held against you. We're here to help.
That's awesome. Thank you so much for sharing your insights today with us, Leslie.
Happy to be here.
Some excellent advice in there. I hope you took something away from today's conversation. Realtors have complex, layered jobs that involve wearing lots of different hats. E&O provides critical protection that hopefully you'll never need to use, but in a profession fraught with the potential for risk at the many turns of a transaction, E&O provides an invaluable service. Go learn more at their website, www.reeoic.com. Thanks for listening today. I'm Jesse Lalime, and I'll see you down the next critical path.